This week, we're going to consider science for environmental law. Initially, we can think about the fact that we've talked a lot about how science influences management and policy through the executive branch, so an agency, a state or federal agency, or the legislative branch, talking to members of Congress or a state legislature and the laws they enact. But the judicial branch is also very important. It sets precedent and establishes much of what we do. Think, for example, Brown versus the Board of Education and how the courts basically desegregated the South. It is a powerful example of how the courts can play a very important role. As scientists, we have to deal with the law in many, many ways in our professional lives, so including contracts. We get a grant that's essentially a contract that has terms and conditions that have to be reviewed, legally reviewed. Legal restrictions on our activities set up by the terms of the grant or contract, but also things like permits that we have to obtain. There are issues of our employment and our rights and privileges as employees, legal rights. Intellectual property is an important issue of law that affects scientists. And even things like privacy. You wouldn't think of it, but there have been many issues, concerns now with respect to email privacy and the right in the fact that you may have to turn over emails that you thought were privileged or confidential because of legal requirements. So in addition to those, scientific evidence and testimony in court can play a very important role in judicial rulings, and we'll show you a few examples of that. So the overview of this lecture, we're going to briefly review federal environmental laws with emphasis on Clean Water Act and the Oil Pollution Act of 1990. We're going to address some legal suits and court decisions related to EPA's implementation of the total maximum daily load for the Chesapeake watershed. And we're going to briefly consider the climate change endangerment finding by EPA under the Clean Air Act and the legal challenges there too. And finally, in a separate presentation, I will give you an overview of some of the scientific issues involved in determining the Clean Water Act penalties and the natural resources damage assessment and restoration related to the Deepwater Horizon oil spill blowout in the Gulf back in 2010. Which I've been actively involved in. And because of this experience, I want to give you some of my personal perspectives from experience serving as an expert witness. So if we think of the most important federal environmental laws, of course, we know about the Clean Air Act, the Clean Water Act. There is a Superfund Act, one that has to do with hazardous substances and cleanup thereof. Endangered Species Act is also a very powerful federal statute. NEPA, the National Environmental Policy Act, that requires environmental impact statements on major activities. The Oil Pollution Act of 1990, which we'll tell you a little bit more about. Resource Recovery, Conservation and Recovery Act, also called RCRA. And Superfund amendments and reauthorization of the Superfund law. And then there's also a very powerful federal law dealing with toxic substances control. So the examples that I will talk about here have to do with the Clean Water Act, both with respect to the Chesapeake Bay total maximum daily load issue, as well as the Oil Pollution Act, as well as oil pollution that comes under the Clean Water Act that basically establishes penalties for releasing oil into water bodies. In addition, we will consider the Clean Air Act with respect to the endangerment findings by EPA in the broader case of the EPA's authority to regulate greenhouse gas emissions because of their effect on climate change. And then we will also talk about another act, the Oil Pollution Act of 1990, which sets a process by which damages can be recovered. Damages to natural resources can be recovered by state and federal responsible agencies after an incident, oil spill incident. So the Clean Water Act is our primary law of governing water pollution. It was first passed in 1972 Actually, there were many environmental laws passed in that era when Richard Nixon was president. It authorizes research, construction grants, sets standards and enforcement, permits, state revolving funds, all related to the goal of improving water quality. So, as this little icon indicates, the law says that our bodies of water in this nation should be swimmable, drinkable, and fishable. Title III has various standards and enforcements that gives EPA and by delegation the state agencies who implement this the responsibility, the process to provide discharge permits. There are some exceptions. I think we've talked about this before. For example, agricultural drainage runoff is exempted from regulation under the Clean Water Act. Initially, the way this was approached was by making improvements in terms of the discharges, requiring the best available technology, best practicable technology for discharges of various substances from point source discharges. There's also provision for water quality-based standards that if water quality standards are not achieved, given the technology-based discharge requirements, then this process called the total maximum daily load can be determined, and then it's up to the responsible party, this federal government or the state, to find out ways to reduce inputs, the loads, pollution loads, to achieve that total maximum daily load. There's a provision for water quality inventories that are done periodically, and then there's enforcement authorities. In this case, we'll be talking about a little later on oil spill fines among those. So the Oil Pollution Act of 1990 was enacted after the Exxon Valdez tanker spill back in the 80s. And it provides it was a wake-up call. It was a massive spill, and we learned that a lot of our response and regulatory authority wasn't up to the task. So Congress passed the Oil Pollution Act that put in place requirements for planning and prevention, containment, and cleanup of oil spills. And it was meant to correct some of the existing problems, as I said, in the Clean Water Act and other acts. The OPA of 1990 set the liability cap for any given oil spill of $75 million, which, if we think of it in light of the Gulf oil spill a few years ago, where the cost of even cleanup, it far exceeded that, much less all of the liable effects and damages to other parties far exceeded that. Congress still hasn't changed that liability cap, though. And the other thing that the OPA 90 did is that required double-hulled oil tankers as a standard of practice. So the Chesapeake TMDL, as I think we've understood from talking about in the previous lectures on the Chesapeake Bay, was established in 2010, after the jurisdictions failed to meet the 2010 goals that were set back in the early in the year 2000 or so for reducing nutrient sediment loads. It was agreed earlier that if they failed to achieve that, there would be a TMDL, total maximum daily load approach, which had, as opposed to the previous efforts, which were largely voluntary, would have the power, the force of law to require that the states actually achieve those reductions to get down to the TMDL. It was the process, though, and very importantly, with respect to the legal issues, was developed collaboratively, involving the states and EPA. It wasn't necessarily imposed on the states. The states worked with EPA to develop a total maximum daily load, and then watershed implementation plans that were allocations to each of the jurisdictions, and watershed implementation plans about how to achieve those reductions. And it was based, importantly, on water quality models, and we've talked about these in the past. That is, helping us to estimate the load reductions that are required in order to achieve a certain level of water quality in the receiving water, in this case, the Chesapeake Bay. And so in 2012, after this first TMDL was developed, there was phase 2 implementation plan submitted. And in this process, they included backstop allocations where the watershed improvement plans did not meet the allocations which were assigned to the states, or where there was reasonable assurance that this would be accomplished. So EPA had to judge this, and on that basis could step in and have backstop allocations to force the states if their plans were inadequate. All of these become very important in the legal case that was argued. So the goal, of course, as we've talked about before, is to meet these load reductions by 2025, and with the 2-year milestones, and with this reassessment that we're involved in this year, the 2017 midpoint assessment we're undergoing at the moment. So in the American Farm Bureau Federation, the main agribusiness lobby in this country, in conjunction with a number of other plaintiffs, including the National Home Builders and a variety of other agribusiness associations, including the Fertilizer Institute, for example, went to federal court and said the Chesapeake TMDL is not legal under the law, under the Clean Water Act, and it petitioned for relief by discontinuing it, not requiring the states to implement the agreement, the TMDL agreement. It said that the TMDL, that is their case, was not legal under the Clean Water Act because it had detailed allocations and it had these reasonable assurances that it affected upstream states, which were required to reduce loads for the benefit of downstream states, and also on issues of how it was being implemented. In addition, there were some procedural violations with respect to public access to information. But importantly also from a scientific standpoint, it said that the TMDL and the models on which it were based were arbitrary and capricious, that the model results were overextended, and that they used flawed data. The defendant in this case was the EPA, and friends of the court, amici curiae, were CBF, Chesapeake Bay Foundation, National Association of Clean Water Authorities. So the authorities that have point sources which were being regulated went to court to side with EPA, to saying, if we have to have these required reductions, then all of the non-point sources and so on do as well. So after the hearing of the case, there was a summary judgment, and the PDF of the presentation has a live link. You can go actually read the full judgment if you're interested, see how the court writes these things and all the detail and so on it's given. It ruled for judgment for the defendant, that is EPA. And it said that reasonable assurance is a practical measure, and it does not infringe upon states' decisions, that the allocations that were given are not binding. The states had an ability to adjust those allocations, that EPA has the authority to regulate upstream pollution in order to achieve water quality standards in a downstream state, that the TMDL is not an implementation plan, that how to implement the TMDL is left to the states and they have authority and flexibility to do so, that the public comment period was adequate, and that the model, importantly, the model was suitable for the purpose. It wasn't perfect, but it was based upon the suitability for the purpose in which it was being used, and it deferred, generally following other federal court opinions. It tends to defer to the agency on the selection of data and how the models are constructed. So the American Farm Bureau Federation wasn't happy with that decision, and they appealed it to the Third Circuit, the regional court in the Mid-Atlantic region. And they were joined by, in this case, 21 state attorneys general mostly from agricultural states. And they included among those Scott Pruitt, who is now, of course, now been confirmed and is in place as the new EPA administrator. And he has now responsibility for implementing the law, which he went to court to oppose. That appeal was made in January of 2014. The appealee, that is EPA, was joined by not only by CBF but by 6 other environmental organizations, wastewater authority interveners, and a variety of cities, states, environmental organizations, and a group of law professors. So it became elevated in terms of a regional engagement and involvement with attorneys general from throughout the country involved, as well as others on the side of the EPA. So the appellants did not appeal the decision on the models or the data. So they left the whole attack on the scientific approach out of their appeal, but they doubled down on this issue of reasonable assurance, that is, providing a case to EPA that they're reasonably assured that the state could implement the plan, and that the issue of allocations was illegal under the Clean Water Act. The court affirmed EPA's TMDL. This is the link to the appeal to the appellate court's ruling, Third Circuit Court ruling in 2015, including the allocation and reasonable assurance provisions. The American Farm Bureau Federation and a whole group of their fellow travelers, in this case, went to the Supreme Court and said, we want you to hear this case, up to appeal it to the Supreme Court. And the Supreme Court, by that time, was reduced to 8 members. If you remember, after Judge Scalia passed away, it denied the petition to hear the appeal. So the appeal has not been heard by the Supreme Court, which becomes important looking at the future. We don't know why they didn't reveal a vote or reason. They don't have to. So we don't know whether they were split 4-4 or in their outlook on the case, or whether there were some other reasons. So this other issue, very briefly, I won't go into as much detail, has to do with climate change and the degree to which it endangers the public welfare. In the state of Massachusetts, this is during the George W. Bush administration, the state of Massachusetts went to court and a suit against EPA and said that EPA should be regulating our greenhouse gas emissions from regulated point sources because climate change is a serious harm in terms of the quality of the air and the well-being of people. The Supreme Court, in this case, found that a 5-4 decision, this is when Scalia was still alive, so they had 9 members, but he was in the minority. He and the conservative members were in the minority. That greenhouse gases are pollutants under the Clean Air Act, and that EPA has a responsibility to regulate them. And so what EPA did is it went through a process to determine whether greenhouse gas emissions endanger public health and welfare of current and future generations. And so in 2019, the end of 2009, EPA released this endangerment finding that it said, yes, indeed, this endangers public welfare. Their technical support document, which we can link here too, is a referenced document based upon peer-reviewed literature, and of course things like the IPCC, the National Climate Assessments through the U.S. Global Change Research Program, and reports of the National Academy of Sciences. And in 2010, EPA then, after public review, denied the petitions for reconsideration of its finding. Those folks went to court and said, EPA is wrong. We want you to overturn this endangerment finding. And the court upheld EPA's endangerment finding in 2012. Interestingly, among those that appealed EPA's finding, went to court to oppose EPA's finding, was the aforementioned, now current EPA Administrator Scott Pruitt. And so he is then, now responsible for EPA, which has to uphold this law. So as we look to this future, what does this mean? We've got some challenges ahead. Will the Supreme Court, now that we have a ninth member, Neil Gorsuch, a very conservative judge, will it now take up the Chesapeake TMDL that it decided it didn't want to consider? Will it now take it up, and might it overturn it? Will it actually revisit this issue of greenhouse gas regulation, either by appeal of the previous finding or some other challenge to regulations and programs and regulations put in place by EPA? Will Administrator Pruitt not pursue the previously adjudicated authorities which were granted EPA by the courts? Will there be lawsuits, if he does, by advocates to be filed? And how will these courts throughout the whole federal process rule on them? And importantly, what role will science play? So stay tuned. We have a very interesting time in which science again is going to be brought into this process, questioned, debated, and have an influence on a major legal determination, which will set the course not only for the Chesapeake Bay, but on addressing U.S.'s contribution to global warming and climate change.